Prosecution Act. At this time, I'm going to give the defendant 45 minutes in order to complete his questions. At noon, we are then going to break. At noon, you will be on your lunch break. We will come back and convene at 1:30 in this court, and at that time, we will select who is going to stay and who can leave. So at this time, I'm going to let the defendant go ahead and ask any questions. Mr. Pierce, this is not time to testify or present defenses. This is merely time to ask the jurors questions as to preconceived bias and or background information. So, sir, I'll give you until 12 noon. That's 47 minutes. You may proceed.
This moment is the proudest moment of my life. Here are my questions. First off, I'm too afraid to ask these questions because I've been threatened with going to jail immediately on the spot today. I don't know if a word I say will cause that to happen, and therefore I am too afraid to ask. I will ask one and see how this goes.
Sir, we're going to stop right there. Sir, the only time that you are at risk of being in contempt in my courtroom is if you are disrespectful to me, a potential juror, a potential sheriff, or anyone who's a party to this case. There's no threat for jail whatsoever, as long as you are not disrespectful. Therefore, sir, you may proceed.
This hearing started at 9 a.m. I request to leave this building and have this jury rule against me in my absence so I can take it up with appeal because I do not trust this judge at all. I think I'm going to be sent to jail and I'm too afraid to speak.
Okay, sir. So you're electing to not be present at your trial at any time in the future. Is that correct?
If you will guarantee that I can get from here to my car and leave with my freedom, absolutely. I object to everything the prosecutor's going to do, everything that you're going to do. All of the history is on CaseNet file to be found. I have been confronted with 3 motions today that I was not allowed to see on CaseNet. Everyone knows I can't see it because I'm not a bar member. You won't let me have one. I can't get an account. I can't click on it to see it. You expect me to defend myself?
Sir?
Motions that limit what I can say
Sir?
under threat of penalty of jail.
Sir, if you desire to not be present during your trial, then I'm going to make the following findings. Number 1, this is a voluntary decision that you have left the court voluntarily. Number 2, that you are aware that the court will proceed in this case. The court will proceed with the selection of a jury. The jury will receive evidence in this case. And the jury will determine at the end of the evidence whether you are guilty or not guilty of these charges. In the event that a guilty finding is brought back by the jurors, the jurors will at that time assess your punishment. And your punishment in this case, sir, could be a range of $1 to $2,000 and or imprisonment in the county jail from 1 day to 1 year. So, sir, if you are willing to take that risk and you want to leave, then I can't prohibit you from leaving at this time. But we will proceed without you, sir.
In order to make this decision,
Sir,
I request the right to the assistance of counsel that I've already requested in 3 different ways that have been denied by you and the judge that was removed before you.
Okay, sir. Sir, you've been given the chance to hire an attorney for 300 and some days. You were also given the chance to file for a public defender, which you refused. Sir, again, if you decide to stay, you can cross-examine witnesses. You can participate in this court. If you decide to leave, then you can leave. What is your decision?
I need a moment to collect my thoughts.
Okay, have a seat. Have a seat.
I'll ask my first question. How about that?
Go ahead.
Can't take time to think. Here's my first question. If evidence shows a dog charged in closed distance rapidly, would you require the person to wait to be bitten before defending themselves?
So you're arguing facts in this case that are not in evidence. That's inappropriate. You can ask a general question, but you cannot ask specific questions regarding this case.
If I had the assistance of counsel from the public defenders, maybe they could help me out with this.
Well, sir, you elected not to apply.
That's an opinion that I don't agree with because of factual evidence.
Very well, sir. You may proceed.
Do you believe discharging a firearm is automatically criminal regardless of circumstances? Does anybody agree with that statement? Can you apply Missouri's absolute defense for shooting a dog during an imminent attack, even if you personally dislike firearms? Missouri has an absolute defense against killing a dog that is threatening you with imminent attack. You cannot
Sir,
prosecute a criminal or civil.
Sir, you're arguing facts that are not in
It's a
evidence.
statute that's in Missouri statutes. Would you like me to bring it up?
Sir, you're arguing facts that are not in evidence. You can ask the jurors questions about their bias and or backgrounds.
Can I put the Missouri statute that says that no crime should be charged here into evidence?
Sir, I'm not telling you how to present your case. I'm telling you what you are capable of doing now, which is asking the potential jurors questions about prior bias and history. You may proceed.
I think everybody sees what's going on here.
Ma'am, if you can stand up.
When I was younger, my sister was attacked by a dog.
Time out, ma'am.
Exactly.
Juror number 21, correct?
Yes.
Okay.
When I was younger, my sister was attacked by a dog. And the owner at the time did not get his dog. So she was dead and they took him to the hospital. They had to put the dog down, but he did not get shot. So the question basically was saying, was it okay to shoot a dog in attack? I don't think so if you cannot get the dog, but if you were offending, trying to make sure that it wasn't killing anybody else, that you had to kill the dog besides kill somebody else, then yes.
Thank you for that. To further clarify, Missouri has an absolute defense for anyone shooting a dog that's attacking it, especially in their own front yard. And the question is, if you personally dislike firearms, would you still be willing to apply the statute in Missouri for absolute defense regarding this incident? Question 4, would the absence of a visible injury automatically mean no imminent threat existed? Does anybody agree with that? That because there's no dog bite, there's no imminent threat?
Sir, you're again arguing facts of the question, or of the case, which you're allowed to in your case in chief. Again, I'll remind you that your questions can be limited to bias and or history. Do not argue facts that are not in evidence in this case.
I can't bring up the fact that the dog attacked me.
Sir, again, this is my last time that I'm going to tell you this. You cannot bring into facts in this case that are not in evidence. You will have ample time in this trial to present any defense you would like.
I would like to bring in the Missouri statute of absolute defense into evidence so I can ask
Again,
questions
sir,
about it.
that is in part of your evidence presentation. This is asking the jurors questions about their bias and history.
You won't let me...
You may
enter any
proceed.
You wouldn't let me enter any discovery into the case so I could defend myself with my own witnesses.
Sir, you may proceed with questions with the
I haven't
jurors.
given discovery to the...
Sir, ask questions or sit down, please.
My question has to be...
Sir, ask questions or sit down, please.
I'm taking a big risk by doing this, but I'm going to make it. I want the jurors that ask to go home to be allowed to go home. Those are the ones I select. And I don't mind who else stands in judgment for me over this. CaseNet file has everything on it. If you have 2 days to consider it, I beg you.
Sir, you know that's improper. I've already advised the jurors to not look on CaseNet, to not investigate this case. You have the opportunity to present whatever evidence that you would like. Today is that day. You can now ask questions about their history, the juror's history, and potential bias. You will have an opportunity to present a defense, if you would like, later today. Ask any questions, or please have a seat.
I'm just burning this moment into my mind because I'll remember it.
So that's not a question. Again, ask a question or have a seat.
If I can be guaranteed I can leave with my freedom, I would like to leave with my freedom in protest of this court. I do not consider it a court, and I dare not speak any further because you're going to throw me in jail. I dare not speak. I don't know what I'm asking. I'm not legally trained. I don't have assistance of counsel.
Okay, sir. So if you want to leave, then pack up your stuff and leave. I've already advised you what we will do
Will you
today.
have me arrested?
No, sir, you can
Will you
leave.
issue a bench warrant arrest?
Sir, you can leave.
Can I show up tomorrow at 9 a.m.?
Sir, you can leave.
With my
You can show up at any time you would like during this
I'm
trial.
only double asking because between 9 a.m. and the jury got here, you detained me and said I couldn't leave with my
Sir,
freedom.
you are entitled to leave, and now you're attempting to prejudice my jury panel. So I'm not going to have you say any more words. Are you going to leave or are you going to stay? This is a yes or no. Okay, sir, you've just made a... You've just made.
I zipped my lips. I don't dare speak because you said one more word.
Okay, sir, now you're causing a mockery of my...
I'm not trying to mock anybody.
So, sir, if you are going to leave and not participate, pack your things and leave. You're doing so at your own peril.
This belongs to you. Is the criminal charges, I can't even say what
Sir?
it is against the other.
Again,
That's your document. I can't take this paper out of the courtroom. I'll be charged with a crime.
That's correct.
It contains the criminal charges against
sir, we will withhold the things that you are not entitled to take with you. Do we have the jury list, Sheriff? Thank you.
Can I have the jury? I can't have the jury list.
No, you cannot.
Okay.
No one can. Okay?
Okay, I'm going to leave now.
Very well.
I don't blame anybody for voting guilty based on everything you hear. I'll just take it up with the appeals court. Hopefully not go to prison for that.
Okay, sir. Have a nice day. You're entitled to leave. Okay, ladies and gentlemen, we are still on the record. This is quite odd. However, it's not unheard of in the state of Missouri. We are entitled to proceed without a defendant. In this case, unfortunately, the defendant will not be able to present evidence, but you will hear evidence. So we will proceed. That being said, it's now necessary for us to select a jury panel. What we're going to do is I'm going to go ahead and discharge you early for lunch, and then we are going to come back at 1 o'clock. At 1 o'clock, we will seat a jury, and we will have a trial. Ladies and gentlemen, follow the directions of the sheriff. Now, I'm going to read you my short recess. Okay? The court again reminds you that what you were told at the first recess of this court. Until you retire to consider your verdict, you must not discuss this case among yourselves or with others, or permit anyone to discuss it in your hearing. You should not form or express any opinion about the case until it is finally given to you to decide. Do not do any research or investigation on your own about any matter regarding this case or anyone involved with the trial. Do not communicate with others about the case by any means. Do not read, view, or listen to any newspaper, radio, electronic communication from the internet, or television report of the trial. At this time, you should return to the jury room, or at this time, follow the directions of my sheriff. You guys, there are all kinds of great places to eat on Main Street. I would encourage you to go down there. You're in recess until 1 p.m. We'll pick a jury, and a lot of you will go home. Okay, so enjoy your lunch. We're going to see you back at 1 o'clock. Thank you.
We will meet back on the second floor of the big jury room, okay, just 4 o'clock. You get lined up and come up here, okay? Everybody meet down there on the second floor, don't come up here, second floor. Here you go.
Hold on for 1 second. Okay. Okay, we're back on the record. I'm going to make a record of where we are. So, ladies, for the record, it is 11:30 p.m. The defendant has advised us numerous times throughout this case that he intends to leave and not be part of these proceedings. He said this before we were on the record, and he just said it on the record. I have advised the defendant that he is free to leave, that the trial will continue without him. And we will pick a jury at this time. For the record, the defendant is gone. And in the event that the defendant comes back into the court at any time, I will note it for the record. At this time, we are going to argue potential jury challenges for cause. And appears in front of me, Stephen Coble and Brennan Murphy. They are the prosecution in this case, and as stated, the defendant is not here. Ladies and gentlemen, our gentlemen, strikes for cause. Do you have any?
I do, Your Honor. I'm going to be handling this for the state, Stephen Coble. Judge, I have two. One being juror number 6, he had work issues, but I also noted he had hearing issues, and on multiple occasions he had to turn his head to try to listen to the court.
Mr. Coble, I noted the same thing, and for that reason, juror 6, I do not feel can be here medically. I question whether he will hear all the evidence. So because of that, we're going to strike juror 6 for cause.
And the only other one, Judge, is juror 21. She said she would need video. She seemed upset about the fact that he could face jail time over this. I don't believe she could be fair and unbiased in this matter, Your Honor.
So for the record, juror number 21 appears to not want to be here. She's advised the court in private that she has 2 sick parents, that she has an 18-year-old daughter who is at home caring for these parents. She's indicated to the court that she will likely be biased in this case, and therefore I'm going to strike her for cause.
And the only other one, Judge, I would say would be juror number 20. I know she had some work issues, and I think the fact that we're going to be fine with the number of jurors that I'd ask that because of, I think, it had something to do with giving birth to children.
Yeah. So for the record, Mr. Coble, juror number 20 indicates that she works for some type of a company that assists in birthing, I believe home births, and that she currently has clients that are possibly giving birth any minute, as she stated. So I am going to allow you to strike her for cause. And there was also another juror who, quite frankly, seemed incredibly stressed.
I believe number, was that 85?
It was number 85. I have watched her mannerisms during jury selection. I don't feel that she is locked in, meaning it appears that she's done some hand gestures, like she can't hear. I don't think she's paying attention. Because of that, I'm going to strike juror number 85 for cause.
And Judge, I agree with everything you said. I noted the same things. I just didn't think she was far enough. I think she was far enough back that she wasn't much of a concern.
I don't think we'll reach her, but I just want to note for the record that she's going to be stricken for cause.
Judge, since the defendant has forfeited his right to be here by walking out of the courtroom and basically forcing a trial by abstention, I would count them. The state would get 2 strikes on a misdemeanor. So that would put us through juror number 47. And then I would put it as, since we get 1 strike and an alternate, that would be 48 and 49 for the possible alternates.
I'm making notes on the jurors that were struck for cause. I show let me go ahead and strike number 61. 61 was excused. And 20 and 21 were
6 and 85.
struck for cause. And then last, number 85 was struck for cause. Okay, so let's go ahead and count the possible individuals that we will include for selection. We have, and I'm going to make a tally marks for these, we have juror 1.
Actually, number 2, Your Honor,
Oh,
John Pence.
okay, so juror number 1 did not show?
Correct.
Oh, I show, yeah, you're right, okay, I'm sorry. Absent. Okay, we have juror number 2. We have juror number 3.
That is correct.
We have juror number 4,
That is correct.
5,
That is correct.
6.
That is correct. No, 6 we've
6 was excused, yes. So keep track of these, guys, so that we know we have the right. 7,
Yes, that's 5 jurors so far, Judge.
okay. 8,
Yes.
12,
Yes, Your Honor.
14 was absent. 17,
That's correct, Your Honor.
19 was absent. 20,
It's been removed for cause.
removed for cause. 21, removed for cause. 26 will bring us to 10 jurors.
26 was absent. Your Honor.
26 is absent, I'm sorry. 28 was absent. 30 will bring us to 10. Are we correct on that
is
number?
correct, Your Honor.
Okay. 31 absent, 32
No, that would
is,
actually be 9, Your Honor.
okay.
2, 3, 4, 5, 7 is 5, then 8, 12, 17, 30.
Okay, 9.
So we're at 9.
Juror number 36 then becomes our 10th, correct?
Correct, Your Honor.
37 is 11.
That is correct.
43 would be 12.
Yes, sir.
46 would be 13.
That is correct, Your Honor.
47
Would be
would be
14.
14.
And that's, we have 2 preemptories, so that would be the first 12.
And then we have juror number 48 for an alternate.
Yes, sir.
And then we will go up to juror number 49 because you can strike one alternate as well.
That is correct, Your Honor.
So I show that our panel will be comprised of those jurors.
Yeah, that was right.
So at this time, I'm going to have you decide, and do you need a minute
Could
to
we
come
just
back?
have a moment?
You can,
time
sure.
So I can
So-
talk to Danielle and Brian.
So at this time, I'm going to have, we're going to take a break from the record and allow you to discuss your challenges.
Thank you, Your Honor.
Thank you. Or your strikes, I'm sorry. Okay. Okay, we're back on the record in our case. This is cause number 2411 CR 03275, State versus Joseph Pierce. The prosecution took some time in order to give us their strikes in this case, and the defendant is not here. So, prosecution, who are you electing to use your preemptory strikes on today?
For the first 12 seated jurors, Judge, number 12 and number 17.
Okay?
So our jurors would be 2, 3, 4, 7, 8, 30, 36, 37, 43, 46, and 47. And then, Your Honor, we wish to strike number, I believe it's 49 for our alternate, making juror number 48 the alternate.
Okay. Let me count to make sure that we're correct. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, and one alternate. Okay, the court will accept this. Our panel will be jurors 2, 3, 4, 5, 7, 8, 30, 36, 37, 43, 46, and 47. Juror number 48 will be the alternate. Just so that you know, I do not tell the alternate that they're the alternate until the end of the case. I think it's inappropriate for judges to do that, because then they snooze during the proceedings. So that will be our jury panel. We can now go into recess. Thank you.
Thank you, Judge.
Record of some things. So when you're ready to go on the record, what's that?
We're ready.
Okay. Court is back on the record on cause number 2411 CR 03275, State versus Joseph Brandon Pierce. It is 12:55, and we are about 5 minutes from the jury coming back for jury selection. The defendant has elected to not be present at trial. The court is always open for the defendant to reappear. If he reappears, I will simply ask him to be seated and participate in the court. If he doesn't, we will try his case in absentia. I wanted for the record to be clear in that the defendant has had multiple, and I mean multiple, opportunities to retain counsel throughout this case. On each occasion, the defendant has informed this court that we lack jurisdiction over him, and that until we prove jurisdiction, he doesn't have to do anything. His attitude today was similar. I wanted the record to also reflect that a detailed Feretta hearing was held on this case on 12/18/25. This after a very, very long Feretta hearing. I set this case for trial. I deemed that the defendant waived his right to an attorney at the conclusion of that Feretta hearing. As to any prior plea of guilty or not guilty, I note that the defendant was arraigned on 2/3/25. He refused to enter a plea in this case, including a plea of not guilty. So the court in this, not this judge, but Judge Sandcork, entered a plea of not guilty for the defendant, and he thereafter posted a $2,500 bond for his release. The court also notes the defendant was directed at the pretrial hearing, which was held on this matter on, let's see, we had a pretrial hearing on February 4th, wherein the defendant was once again directed to obtain an attorney. Can you hear me? Okay. Where the defendant was once again directed to obtain an attorney, and he failed to do so. At this hearing, the defendant indicated that he wanted to plead guilty, and then I gave him the opportunity to think about it, and he came back into the courtroom 5 minutes later and said no, he did not want to plead guilty. He wanted to go to trial. The defendant also then informed us that he was going to apply for a public defender. As of last week, I was informed by the public defender's office that he made inquiries, but he did not fill out the application, and they would not be entering for him. So that's the record that I wanted to make today. We will continue the trial in his absence, and we will seat a jury next. Before I proceed in seating with the jury, I did receive a possible report that the defendant may have left the building and may have had some interaction with some of the jurors. Because of that, I'm going to reopen the voir dire, and I'm going to make inquiry of the jurors as to if he did, in fact, reach out to any of the jurors. And if he did, I'm going to call the jurors up individually and ask them what he said. We have selected a panel, but if any of the panel has been compromised by any statements that he has given to them or any possible threats or for any other reason, I want to flush it out before we seat the jury in this case. So that being said, we will go off the record now. We're going to bring in the jury panel. Jurors and may have said things to them. So I'm not going to taint the jury panel, right, with anything that was said. I'm going to bring the individuals that he had conversations with up to the bench, and we're going to discuss. So we're not going to cross-examine you. So here's my question. You had contact with the defendant outside of the courtroom, correct?
Outside the courtroom. Was in the room.
Okay, what, did he say something?
He checked case that.
Okay.
That's all I can say.
Okay, all right. And you know that as a juror in this case, that you cannot check a case now. Okay. And you won't be through the trial, correct? You understand what case net is? Okay, it's just a history of the case. Okay, very well. And you don't feel that what he said is going to prejudice you in this case, correct?
No, not what he said, no.
Okay, all right. Is there anything else that you feel is going to prejudice you?
The way he's acting.
Okay, all right, I understand. I understand. And then I'm going to, there'll also be, if you're selected as a juror, there'll be jury instructions to direct you on what you can and cannot take into account. Okay, have a seat.
80 and 80, I think were the other two.
Okay. Okay, 80 and 81 were the other two that he said something to, right? Juror number 80, come on up. Juror, yeah. I'm sorry, 81, come on up. My bad. And 82, is that right? Okay, I'll have you up next. Juror number 81, come on up. Okay, ma'am. I understand you had conversations or you heard him. Okay, all right, so nothing that he said to you gave you any information or anything about the trial? Okay, all right, no problem at all. All right, have a seat. 82, come on down. Hello, ma'am. So, what did he say to you?
I mean, I just kept walking, but he was at the door when I was trying to exit.
Okay, so nothing he said to you is going to cause you to be prejudiced or anything, or biased in this case. All right, no problem. Have a seat.
Number 96 as well.
Okay. 96? Sir, juror number 96, I understand he had a conversation with you or said something?
I overheard some people from the court.
Okay,
Not anybody in this room.
okay, all right. I can tell you that you're down on the list and you're not going to be selected. So,
It doesn't matter.
Yeah.
It's okay. I
Yeah.
just was worried about
is there any?
appearance of impropriety.
Yeah, and there's no appearance of impropriety, so you're good. Good, have a seat. Okay, prosecution, are you satisfied with the questions that I've asked the jury members?
I am, Your Honor. I think 3 of the losing where they
Okay,
So 81, 82,
right, and 80 and 43 clearly said that,
well, I think there may have been an attempt to tamper with a juror by the defendant. I don't think there's been any shown that he has changed his mind and that he can't be fair and impartial.
I agree. Okay, then we will proceed. Thank you, guys, have a seat. Ladies and gentlemen, I will now call the number of the 12 jurors and the one alternate who will be the jury for this case. As your number is called, please take your seats beginning in the back row. Follow the directions of my sheriff in the corner and be seated in the jury box. The juries that will be, or the jury that numbers that will be hearing this case are number 2, number 3, number 4, number 5, and that's it for that row. So jurors number 2, 3, 4, and 5. In this row, juror 8 and juror 30. Come on down.
I think juror 7 was one of our jurors, too.
Did we miss 7? Yes, number 7. Come on down. I'm sorry, man. Mike, I missed 7, so I'm put. Okay, thank you. Okay, in the next row, jurors number 36, 37, 43 have been selected. So come on down. Also, jurors number 46 and 47 have been selected. So let me take 36, 37, 43, 46, 47, and juror number 48. You too.
Number 37, followed by 43, then 46, 47, 48.
Mr. Prosecutor, Mr. Murphy, and Mr. Coble, is this the jury that you have selected?
Yes, Judge.
Yes, Judge.
Very well. The remaining members of the jury panel will not be needed for this trial. If and when your services are needed again, the court will notify you. I hope that you feel good about your service here today. Jury service is an important obligation as a citizen of the state of Missouri. You have done your duty under the Constitution of the United States and the constitutions and laws of the state of Missouri. You have provided a valuable service to the cause of our justice in this community. You may either leave today or you can stay and listen as you would choose. Thank you for your service. You are excused at this time.
I'll take all your badges right here.